All right, we are on YouTube also, and I will remind all the parties that recording anything either off of this Zoom conference or the YouTube recording is prohibited and will be punished by contempt and any other issues, any other methods that the court can employ. Do the parties understand that?
Yes, Your Honor.
All right, we're on YouTube also, and I will remind all the parties that recording anything either off of this Zoom conference or the YouTube recording is prohibited and will be punished by. Okay, there we go. All right, so now are the parties ready to proceed?
Yes, Your Honor.
Your Honor.
Yes, Your Honor, we are.
All right, so Mr. Platten, first of all, one of your arguments is exactly the same, is it not?
No, Your Honor, we have different arguments before the court because everything changed with how things were handled at the 34.6 hearing. As the court knows that you paid attention to the Sixth Court's order where they wanted to have the 34.6 hearing preliminary to the recusal. However, it went in a different order. And things that I want to inform the court about is how my client was really deprived of evidence that would assist in his defense and how things were entered into findings of fact and conclusions of law. I believe the court has the file and you have the different findings of fact and conclusions of law there before you. There are two different sets, one from May 5th and one from May 7th. So I'm going to give you just a moment. And also, did the court receive the 34.6 transcript that was emailed last night?
No, Mr. Platten, why would you be emailing the night before, a Sunday night before a hearing that has been set several times? No, the court has not received it.
Okay. Well, I'm not going to refer to specific areas of it, but I provided it for the court's review and when considering this at the end of the hearing.
When did you send it and what email address did you send it to?
I sent it to Terry, Your Honor.
Just a second and I'll check with my court coordinator. Can you check with Terry, see if she's. And what time did you send it, Mr. Platten?
It was 9-something last night.
You may
and like I said, I'm not going to focus on.
You may begin your arguments.
Okay. The test before the court is to determine if for recusal is whether a reasonable member of the public at large, knowing all the facts in the public domain concerning the judge's conduct, would have a reasonable doubt that the judge is actually impartial. We've asked the court to take judicial notice of the file and all of its contents. And you also acknowledge that you're aware of the Sixth Court order in its footnote on page 3 that a hearing regarding the 34.6 should have been preliminary to the motion to recuse. Your Honor denied recusal on April 22nd, and that hearing on the fact dispute was recorded and was held on April 29th. Now, that hearing was transcribed and it should have also been recorded on YouTube as per the Office of Court Administration's instructions that are given before each hearing. Now, it's our position that wrongfully withheld evidence was kept from my client, and basically we were requesting that the court review or allow independent parties to review the audio, kind of like it was reviewed in the Routier case. And I'm sure you're familiar with Darlie Routier.
I'm familiar.
In the Routier case, they had some problems where there was content missing, and it was pointed out.
Mr. Platten, before we get to that, okay, that would be up to the trial court, not up to me to make that determination. And if Judge Russell has denied that request, don't you have availability? Doesn't the Court of Appeals have the authority to order him to do so?
Well, if I did not make this objection and try to obtain an independent party to review the transcript, I would waive that. And that was discussed en route here. And that's why I bring it to the court's attention, because that's how they were able to preserve error in that case.
I understand, but as far as a motion for recusal, first of all, that is if you're asking me to recuse Judge Russell based on his rulings on that, that is a recusal based on his rulings. And secondly, you have the ability to take that issue up to the Court of Appeals. So how is that a basis for any basis for recusal?
I'm going to point out the bias that was in place into the 34.6 that was not requested by any party whatsoever, Your Honor. Specifically, there was
Mr. Platten, you are muted. Let's continue, please. Yeah, I'm going to have him repeat. All right, Mr. Platten.
apologize for that disturbance, Your Honor.
You could go back with your argument. The last part you said was something that was not requested by either party. You may continue.
Yes, Your Honor. In the findings of fact and conclusions of law, if the court will take notice of that in the file, there are two different findings. One on May 5th and then one on May 7th. And the bias that I'm pointing out to the court is how it is implied that it was my request that the court review the information the way they did. And that's entirely not true. And I'm put into this corner where these findings of fact have gone up, and it gives the impression that this is how I wanted this to be reviewed, and it's not. And in addition to that, Your Honor, after these initial findings were filed on May 5th, the court, I guess, thought that that might not be enough. So they came back on May 7th and included an extra paragraph when there was no testimony whatsoever, no evidence put into the record by counsel, by attorneys, that the National Court Reporters Association's advisory opinion 38 concluded that absent any court order to do so, there is no ethical obligation for a court reporter to provide a copy of backup audio media to any person requesting same, or even to disclose those present that a backup audio is being made. And it goes on some more. Now, this is evidence that was included into the findings of fact and conclusions of law that you will not find anywhere in the 34.6 hearing, because it was not asked of me, it was not asked of the state's counsel. Judge Russell made a lot of comments and went on and talking about how things are handled in this courtroom for a voluminous amount of time. But when you look at the findings and the evidence that is available in the 34.6 and compare that to the findings of fact and conclusions of law, you'll see where he is now acting as a lawyer, interjecting evidence into the case that was not interjected by anyone but himself. Now, that's why I go back to how these hearings have been reviewed before. If I don't object and I don't request this, we wouldn't be hearing anything about how I wanted to hear these recordings, or at least have some independent third party review. In Routier, they appointed 3 different reporters. Those reporters first looked at different areas of the transcript, and all of them came to the same conclusion, that the reporter's record had been changed, and it could only have been changed by someone that had listened to the audio to make the changes they made. And in that particular transcript, there were over 20,000 different alterations. that was Susan Simmons had to go back. She was appointed to recreate the transcript. And in her affidavit, she even talked about how these audio recordings and how she knows that the audio tapes may be certified by persons made them.
And Mr. Platt, and I'm familiar with the Rudier case. However, again, I want you to focus your arguments on anything that relates to Judge Russell's bias. I'm not going to, this court does not have the authority to just say, well, Judge Russell's wrong on that. And that's up to the Court of Appeals if you have preserved your error. So please move on to how a reasonable person may believe that Judge Russell has a bias in this case.
A reasonable person, knowing all the facts and circumstances of this case from the beginning, if they looked at this and saw how it was handled and saw how the court has interjected himself even into other hearings, bringing up this case. And that's where I bring the court's attention to Joseph Hart. And in the Joseph Hart case was another revocation case that was held on July the 20th. And in that particular case, I requested access to the pre-sentence investigation report pursuant to Code of Criminal Procedure 42.8.255. And the court was not very happy. I'm holding a copy of this. It's available on Odyssey for the court to look at. That's in cause number 007-110319.
Do you have a copy of that? Was a copy of that provided to this court? Since I can't have access right now to Odyssey of Smith County.
A copy has not been provided to you just yet, Your Honor, but I know that you have access to these things and I can send that to you. But what the court should also have, and what I was going to bring up, is that these hearings are being, audio recorded and video recorded just like now. And whenever the record doesn't accurately reflect some things sometimes, it may be necessary to go back and view the YouTube video. And that's why I'm bringing up just something that happened in the Hart case, because in the Hart case, after requesting this pre-sentence investigation and the order that came out in that case, the judge was not very happy with that. And he came out and made comments during the Hart case about Mr. Moore's case, calling this scurrilous. And I believe the court is aware of what the word scurrilous means. Now, its definition, it's an adjective using or giving coarse language with containing obscenities.
Let's move on to.
Okay. Knowing that he is making repeated comments in other hearings about this, being angry about this case, it's difficult for anyone in the community to look at this from everything it is and would be able to know that this judge is impartial. And that is the test that we have before us. If you looked at those findings, looked at how he's acted in other hearings, which is available and recorded, and like I've said, words are words, but actual visual content and listening to tone and demeanor, and that is available now in the time of COVID. If that is recorded and available, I would recommend that the court, look at that hearing of Joseph Hart to see how the court was handling these words towards me and basically saying that this was scurrilous. And for anyone to know that that word was being used towards Mr. Moore, it would really bring into question whether or not, Judge Russell can be impartial in this particular case, because no member of the public could view Judge Russell's comments as not biased. This 34.6 rule is here to clean up problems that we have with certain records. And we, issued another opinion so you could try to make a decision on this to whether someone should be appointed to review this record from an impartial motive. All I want is this record to be reviewed properly. I wouldn't be going through these steps. I don't enjoy doing this, but I was the counsel in this case. I was there at the table. I'm not some, Monday person reviewing somebody else's actions. I know what occurred in the courtroom, and it's not reflected on the transcript, and the bias is going throughout this case, Your Honor. And in the Perez case, they actually listened to the audio in that case. They actually sat down in court, played play to clean up any kind of discrepancies. That case is 2017 Tex App Lexus 8111. And in that case, they were having issues with the transcript. So they sat down and played it to clear everything up. If this is reviewed by someone that is impartial, as I first requested, someone that can review this thing and come to a determination as to what the proper record is, we wouldn't be having the problem that we're having here today, because my client is being deprived of evidence to assist him in his appeal. We're here saying that he did not receive a fair revocation hearing. He didn't receive a fair 34.6 hearing, which the Court of Appeals wanted to have as preliminary to the recusal. And here we are again. And what we're asking the court to do is to review that 34.6 hearing, come to your own determination if you want to review some of these YouTube videos out there that are available in Joseph Hart or the 34.6 hearing, and to ask yourself whether a reasonable member of the public at large, knowing all the facts the public domain concerning the judge's conduct, would have a reasonable doubt that the judge is actually impartial, because that's the test that we have to get over here. And it is important for us to have impartiality in these cases. And I don't know how Cecil Moore has any chance of any impartial rulings with Judge Russell. And that's the reason why we're here, Your Honor.
And so, Mr. Platt, is it your part of that, your argument that Judge Russell was not justified? And how are you saying that Judge Russell's review of the appellate record was against the rules? Just because he didn't play it in public or let you hear it, there's no, in my reading of 34.6, there's no requirement of that. It just says that the judge shall, the trial court must, after notice and hearing, settle the dispute.
Yes, if the dispute can be settled. And in there, he makes claims that Platten's claims are patently false.
Okay.
And that's not true, Your Honor. If you listen to the audio, you'll hear how my claims aren't false. I wouldn't be here if these claims were false. He's over there grading his own papers when this should be reviewed by
Mr. Platten. Is there somewhere in the statute that you can point to where Judge Russell has to do it the way you want it done?
34.6 allows discretion in how this is reviewed, but we shouldn't hide behind. Let's think of the statute of frauds. The statute of frauds can be used to perpetrate a fraud as well. 34.6 can allow us to recreate a record, or it can allow us to hide a record. Do we want to just sit back and allow someone to be a guardian of the record and say, well, I've been told if I review this 4 or 5 times, and if I keep saying that it's good, it's got to be good? Or do we actually understand that people are people and things can be changed, and that we would like independent review at times? And this is a situation where independent review is necessary to get to the truth, to see the evidence that's been deprived from the court as being deprived of Cecil Moore in his cases. And we can hide this And we can say, well, case law says this and case law says that. Well, case law is not on point with anything in 34.6. And in this particular instance, here we have an opportunity before the record is on file with the Court of Appeals to clear this up. In all these other cases, in Routier and Perez and all these cases, the states and Mr. Files' side as well, we have cases that are already up at the Court of Appeals. Here we are saying we have issues before the record even gets up. And I am imploring of the court to use your authority to appoint someone to review this record that would be impartial, that would be non-biased.
And what authority do I, as the regional presiding judge, have to appoint someone to hear this?
You, as a reasonable, well, right now, you are sitting as the judge of the 7th District Court, correct?
No, I'm sitting as the judge for the purpose solely of a motion to recuse.
I understand, but in this particular hearing, you are acting as the judge of the 7th District Court for the purpose of this hearing, but you have other matters that have been brought before you, other issues that you know that the 6th Court of Appeals wanted us to resolve preliminary to a motion of recusal. And that's why we're having these problems here that I bring to the attention of the court. I am now asking you to do what you have in your authority and to appoint independent individuals that can be agreed on or that you would like appointed yourself, just like they did in Routier. You can appoint 3, you can appoint 1, you can appoint Susan Simmons over in Marshall, Texas. I've already spoken with her and discussed how that was handled before. And I've read her work and I've reviewed these cases in Perez. It's not that difficult for Ms. Lawrence to have this audio to where it can be determined if there's been any hash marks or changes in the audio. That can simply be done with the computer. Now, court reporters know when there have been changes and how they can compare that to audio. They did that in Routier, they did that in Perez, and they've done that in other cases. When a forensic review is done properly, we wouldn't be having any of the problem here. All I'm asking for is a proper record for my client so he can have the evidence that's been withheld. So you now sitting as the judge for the 7th District Court, you have authority. You can either determine, is Judge Russell biased by his actions where he deprived my client of this information, where he embedded evidence into the findings of fact and conclusions of law, wanting the 6th Court of Appeals to believe these were my ideas for the record to be reviewed this way when it was not, when you will read yourself in the transcript that this was Judge Russell's idea. I asked at the end, if you're not going to do anything, go ahead and read it. But we would like all these people to do it impartially. And that's not how he said. He said he'd review it. And he asked what pages to review. And a particular page was pointed out. But the entirety of this needs to be reviewed by this court. This is important. And you have that video to where it can be provided to you, that YouTube video of that hearing. So you can make a determination yourself how you think it was handled, as well as Joseph Hart, where you can go back and look at his comments toward me about being scurrilous. So if I'm being scurrilous, does that make you think that someone may not be impartial when it comes to reviewing this information? How is my client going to get anything fair in this case? He's not. And that's why Judge Russell should be recused from this case, because he is impartial due to his bias, due to implanting all of this evidence in the findings of fact and conclusions of law and trying to make it look like it's my idea. Lawyers introduce evidence in the cases. The judges don't. The judges call balls and strikes, and they don't put all this information in there. They just set it on up, and it goes however it's going to go. out of thousands of appeals out of this court, there's been only one reversal. And that was due to a federal question. I don't know what's going on with these records, but I know that I got a problem with this one because I was there at the table. I know what happened.
Mr. Platten, you know, right now, your comments are bordering on scurrilous. So be professional. Are you done with your arguments at this point?
I would ask the court to determine how the public at large, looking at this entire record, would view this, and whether the public at large would view Judge Russell's actions as impartial. We would ask the court to also appoint someone to review these records properly. Thank you, Your Honor.
All right, response by the state.
Your Honor, first of all, I haven't heard from Mr. Platten how this is a timely motion to recuse. In the response I filed, I pointed out explicitly that he has provided at least 3 prior motions for Judge Russell to rule on, one being a motion in continuance. And after Judge Russell ruled on those 3 motions, then he filed a motion to recuse. And my first objection to this whole process is that he hasn't established that he has timely filed this motion, because he's taking advantage of Judge Russell's rulings in those motions that I have attached to my response. And the law clearly provides under Civil Rule Procedure 18A, B1 and 2 require that it be done as soon as possible, as soon as the reasons for the motion recused become apparent to counsel. And he's already explained to the court that he's talking about an April 29th of this year, a hearing where everything that supposedly happened at Judge Russell was illegally withholding evidence from him. But he didn't file a motion to recuse until August 3rd of this year.
All
So
right.
first of all, I'd like to hear how he thinks this is a timely motion, because it's not.
All right, Mr. Platten, as to that argument.
An additional hearing was set by this court because the 6th Court of Appeals again wanted another hearing to determine why we were having problems with the record, Your Honor. The 6th Court of Appeals, they came down and I'm not certain what date it was filed, but they had questions in reference to the record and the information that was being sent by the district clerk, and how we had missing information. I believe that was July 22nd is when that new order that came down from the Court of Appeals, where they requested another hearing to look into the clerk's records and the reporter's records. And just shortly after July 22nd, when we were getting ready to have that hearing, I had issued subpoenas for different individuals to appear and give testimony at that hearing. And then I got sick with COVID, Your Honor. So all I can say is that I was impaired and I'm still recovering. That was right around the time that I was getting sick. So all I can say is that if there was any delay in requesting a recusal of that particular hearing and to go forward with the problems that we had in the 34.6, it's because I got COVID and I'm still recovering from this.
If I might, Your Honor, brain fog is not an exception to the rules under the civil procedure. You have to file a timely motion. He filed this hearing that was held April 29th of this year is the basis for the motion recused that was filed on August 3rd of this year. In between those 2 dates, he filed 3 motions and had Judge Russell rule on those motions. And then after he obtains a continuance from Judge Russell, he filed the motion to recuse that we're here on now. So I haven't heard an explanation why he can come in here and allow Judge Russell to rule on 3 prior motions, knowing back in April that the grounds for this motion for recuse occurred back in April. It's not as soon as possible, Your Honor. He hasn't filed a timely motion.
We have prior motions still on file that he hasn't, even ordered. We have objections with the court that were filed June 18th that still sit there, objections to these findings of fact that still sit there unanswered. Now, apparently y'all aren't too up with the effects of COVID and what this can do, but also outside of that, and we want to talk about the law here, the Supreme Court has also held that certain timelines can be stayed during this time of COVID. Now, if you want to go back to talking about timelines or anything, I would.
Mr. Platten, the court is familiar with the timelines. So I'm going to ask the state to present the rest of their argument, and then I'll see where we are on, where we stand on any further motions in this case or testimony. So the state may proceed with the rest of their argument.
Thank you, Your Honor. Initially, the state would point out that the hearing that was held on April 29th, that Judge Russell was ordered by the Sixth Court of Appeals to determine the accuracy of the record after Mr. Platten made false allegations that Judge Russell and his court reporter, Ms. Lawrence, had falsified the record in this case. And the court, it should be important for the court to understand that this is not a complex case, Your Honor. This was a guilty plea. He got a deferred adjudication from a guilty plea, and then he pled true to the motion to adjudicate. So it's not like we had a long, drawn-out hearing or anything. These were simple hearings that a judge performs every day in court. And now, at the hearing to determine the accuracy of the record, you pointed out the fact that it's Judge Russell's duty to determine whether the record is accurate. There's nothing in the rules of appellate procedure that require that Judge Russell appoint an independent person to review a claim that a record is inaccurate. In fact, it's just the opposite. Judge Russell was ordered by the Sixth Court of Appeals to review the record, and the case law allows him to decide the method to review. He decided, as case law provides, that he was going to personally listen to the portions of the record, and only after he had Mr. Platten narrow it down to a specific point that he claims was an error. And by the way, there was testimony in the record from the prosecutor, and of course, the point that Mr. Platten's making is there's an objection that doesn't appear in the record that he claims that he made. But this is his second claim on that. Originally, he claimed there were objections, there was testimony, there was argument on the part of the prosecutor that referred to the PSI. Once he was put on the stand and asked specifically what it was he thought was missing, he narrowed it down to one objection based on what he claims was the prosecutor's use of the PSI. And the prosecutor specifically denied under oath that he used the PSI. And in fact, the question that Mr. Platten objected to would be referring to matters that occurred after the preparation of the PSI. It wouldn't be in the PSI anyways. So assuming he made the objection and it doesn't appear in the record, but that's not the case. But in any event, Judge Russell did what he was ordered to do. He did what he had authority to do. He decided that the record was accurate, and records are determined and certified by court reporters every day to be accurate. So they are the guardians of the record. If he says there's no guardian, they are the guardian of the record. And they make a determination based on their experience and their presence in the courtroom that a record is accurate. And that's been sufficient for courts of appeals for years. And so that's, first of all, that's regarding Judge Russell's claim that Mr. Platten's claim that Judge Russell was acting as counsel in the case as a reason to disqualify Judge Russell. That's just clearly not true. Based on the record, Judge Russell was doing what he was ordered to do in a manner provided for by the rules of appellate procedure. That's not acting as counsel, that's acting as judge. And that's what he did. In regards to recusals, I haven't heard any evidence. I've heard Mr. Platten say that in another case, Judge Russell called him scurrilous. And I think it's appropriate if he did call him that. But the fact remains that the case law provides that Judge Russell was irritated by Mr. Platten's repeated motions to recuse based on false claims. If that irritates the judge and he has some say about it in another case, assuming it's even happened, because we haven't heard any testimony yet regarding what actually happened in that other case. But the case law provides that judges, as an imperfect human being, is allowed to express some dissatisfaction with claim a counsel makes. That's not grounds for a recusal. That's our second response. Thirdly, the grounds of recusal he hasn't shown that the grounds of recusal have arisen from some extrajudicial source. Based on the cases cited in my response, it can't be just the judge's rulings or reactions to evidence in the case. It has to come from someplace outside of the case that establishes a bias. And there hasn't been any evidence of that. And then finally, Your Honor, there's a presumption of judicial impartiality that Mr. Platten, in all the arguments, he wants to make claims that Judge Russell is impartial. I haven't seen anything in the record to establish that. Judge Russell has been following the law. He's been doing what he's been ordered to do, and he's done it in a timely fashion. The reason we're sitting here today is not because of Judge Russell. The reason we're sitting here today is because Mr. Platten continues to file these baseless motions to recuse, and it should be overruled, Your Honor. That's it.
All right.
That's all I had to say.
Rebuttal argument, Mr. Platten.
Extrajudicial is entering evidence into the findings of fact that were not included in the 34.6 hearing. Putting evidence in and amending this order is not acting as an impartial judge. Including information from the National Court Reporter School that was not in there whatsoever is not being impartial. That was not information that was held in the 34.6 hearing. Judge Russell quashed the subpoena, made the decision himself that he was going to review it, and just allowed us to have a hearing on that. And all that information is before the court to review, as well as the YouTube and the transcript, Your Honor.
And again, Mr. Platten, I go back to the statute. I go back to the case law. Is there anything improper by Judge Russell determining himself that he will listen to the audio recording and make the determination?
Under these circumstances, with these findings of fact, Your Honor, I believe that it is impartial on its face with the findings, on the evidence. You can review the 34.6, and when you do, you'll see that this information was not brought out by anyone else. It was implanted in the case by Judge Russell. So when he is including evidence, when he's not a lawyer in the case, he's starting to act as a lawyer because he's going and doing his own research and he's making his own findings for information that did not occur in the hearing and leaving it to...
Mr. Platten, are you saying that when I make findings of fact and conclusions of law, I'm stuck with just what the parties present and I can't go out and do my own research on case law or statutes or learned treatises that may be applicable?
You can do research, but there becomes a fine line as to adding in findings that did not occur within the course of the hearing. You're a little stuck with the four corners of what happened in the courtroom. And when it didn't happen in the courtroom, those aren't findings that happened in the record.
Judge, if I might.
Hang on, I'll give you a chance. Anything further, Mr. Platten?
Your Honor, I'd like to note for the record that the Sixth Court of Appeals specifically gave Judge Russell the authority to make any additional findings he felt were necessary. That's not evidence. That's judge making conclusions of law and findings of fact as required by the Sixth Court of Appeals. They said he could make additional findings.
All right, thank you. All right, Mr. Platten, you may continue.
Well, I don't know if we're going to have additional findings after this hearing or not, but he changed it twice. May 5th, he did his findings. He gave it some thought, gave it a day, gave it another day, and then thought to himself, you know what? I've got some more information to put in there. That's not being impartial. That's being biased.
Okay, Mr. Platt, okay, say I make some findings on another case, and then I decide a couple days later, you know, I should have added this part, or I should change these. I don't like the way it reads. Are you saying I don't have that authority?
You do have that authority if it is within the confines of the case itself. But when you start going outside the record and implanting information into that, you're entering in extrajudicial information that was not introduced in the case. So when you're putting in this extrajudicial information, you're going outside of what you should be entering into the findings. If it was introduced, which it was introduced, which you have the 34.6 transcript available for review that you can review later. And you can also review the YouTube video, if you so desire, of both hearings. And for, you know, let me just say that it's proper for him to get angry with me in another hearing, that to show that he's irritated with me. This Mike West is basically saying, yes, Judge Russell is irritated with me, and that's okay. That a judge is allowed to be irritated with me and show bias, and that's okay.
No, his argument was not that he could show bias. His argument was that he could be irritated with a lawyer. I'm sure there's times when lawyers get irritated with judges and vice versa. That does not make every time somebody is irritated with one of the parties a recusable circumstance.
Well, in this particular case, you really should listen and watch the video of how he addressed counsel. There's one thing for it to be written down on paper. There's another thing when someone's looking you in the eyes and saying so much more, Your Honor. That's where I would implore you to look at the video of Joseph Hart.
All right. Anything further by your side?
If I might, Your Honor, it's not your duty as the judge presiding over this motion to go and find reasons to recuse Judge Russell. It's Mr. Platten's burden to prove his reasons. And for him to sit there and ask you to go look at this, go look at that, he's asking you to do his job. And that's not your duty, Your Honor. You're here to recuse, to hear the motion to recuse and to listen to the evidence Mr. Platten might have in support of his motion. He hasn't presented any.
The information I'm asking the court is stuff that is not at my disposal. The court controls their YouTube videos. I don't have access to that. I can't request that, and it's not going to be provided to me. But you, sitting as the judge of the 7th District Court, you should get this, and error should be on the side of recusal here to show that we do have an impartial judge.
All right, I've heard arguments on this. I'm prepared to make the following findings and rulings. First of all, I find that the motion itself was not timely filed. And while the Supreme Court has granted authority for certain timelines to be waived, the Supreme Court was also in looking at this is not one of those timelines that normally should be waived. There's a specific reason why there should be at least 10 days prior to a hearing, and further that it should be done as soon as practicable. So it avoids unnecessary delay. But even if a court was to find that it was in some way timely filed, court further finds that this motion is based solely on the judge's rulings. The Judge Russell, from reading what the 6th Court of Appeals did, from reading 34.6, was operating totally under the law and had every right to review this on his own. And court finds that there is no showing of bias or that his impartiality may reasonably be questioned. I find that this is based totally on Judge Russell's rulings. Based on that, I'm going to deny the motion to recuse. Further, while there was a motion to quash filed and subpoenas for Ms. Lawrence's audio recordings and other records, I'm going to deny those. This case goes back to Judge Russell for any further hearings. and may proceed at that point. Any further motions to recuse at this point will be treated as tertiary, and Judge Russell can still rule on any pending hearings or motions until this court or some other court takes action on the motion to recuse. But since this would be, any further motions to recuse would be a third motion, it would be tertiary, and that rule under the Civil Practice and Remedies Code would apply. I will sign and file an order probably this afternoon denying the motion to recuse. If there's nothing further, we are adjourned in this.
There is something further, Your Honor.
Yes, sir, Mr. Files.
Speaking on behalf of Ms. Lawrence and also a housekeeping matter, at the last hearing, the court inquired of Mr. Platten as to whether or not he had communicated with Ms. Lawrence for a designation of the record. And he indicated that he could not communicate with her because she was represented by counsel. On September 22nd, we sent a letter of certified mail return received requested to Mr. Platten, which contained the following sentence: Ms. Lawrence and I would waive any and all objections which we might have to your communicating with her concerning the record in the above referenced case. There still has not been any designation by him. Second, what we have is a situation where there was a motion to quash, a subpoena. Thereafter, another subpoena was issued, which was almost word by word and line by line, the same as the subject of the motion to quash. There was no request for the court to reconsider its motion. It was simply filed, and Ms. Lawrence has had to go through complying with the subpoena because she could not know for certain what the court's ruling would be. It would seem that Mr. Platten is engaging in a process of attempting to harass Ms. Lawrence. If the court will remember, we had a motion for continuance last time this was said, or 2 times ago, because she had a doctor's appointment that had been set for a year. Mr. Platten did not object to the continuance, but he objected to her not being present to be sworn in, which obviously would be inconsistent with her being able to be at the doctor's appointment. Unless the court
We didn't object. The court ruled that the quash was denied.
May I continue, Your Honor?
You may continue, Mr. Files.
Thank you. We believe it would be appropriate for the court to warn Mr. Platten that requesting the same or having the same subpoenas issued for the same material after there have been 2 motions to quash granted could be the basis for a contempt finding.
Mr. Platten.
In the absence of a change in law or facts.
Platten, as far as I am going to admonish you that filing the same motions over and over could result in contempt findings by the trial court if they are proven to be harassing in nature or frivolous. So I would ask you to take that into consideration before any further filings on those on the designation of subpoenas, unless there's changes in court orders or rulings or changes in the facts and circumstances. So this time I've made my ruling. I will file an order this afternoon, hopefully. And if there's nothing further, we are adjourned.
I would just once reiterate that there is a pending objection before the court that has not been ruled on in reference to the final.
Which was
law that was filed on 6/18. That's all I have to say, Your Honor. That's for record purposes.
okay. All right, then if there's nothing further, we are adjourned.
Thank you, Your Honor.